a very short discussion from my first is sitting as a judge in any court, be it at the first level of the superior courts, or the appellate COA, or the Supreme. Whenever a judge is applying, rating the Constitution, it is imperative for the judge to understand the historical background of the issue at hand. Why do you think that is important?
Thank you, my Lord. It is important to understand the historical background because it raises the basis of the legal issues that need determination. Without a proper understanding of the background, the judge may not understand what the parties before him or her is seeking to achieve. So it's important to understand the background of every dispute that comes before the judge.
Background of the dispute, per se, I'm referring to the understanding of the historical background, that provision of the Constitution, not of the case before you.
Yeah, okay, thank you. Yeah, it's important to understand the historical background of the provision or the law being applied so that then the judge can be able to effectively meet the aspirations of the people that have come to seek justice, and also to ensure the legal provisions being applied are the right ones and can be defended.
Okay. Does that have anything to do with the transformative nature of the Constitution?
Yes, it does, and the transformative nature of the law, really. It's ever developing. The Constitution is, particularly the Supreme Court, is always being confronted with unique issues that have not been determined before. So it has to sort of give pioneering guidance.
Okay, we may hold it at that. And just something on elections, and let's go to the issue of validity of votes. And on this issue of validity, I want us to narrow it down to one of the jurisdictions of the Supreme Court on elections, which is the presidential election. If we run through Article Constitution, this is what a candidate shall be elected president if the candidate receives more than half of all the votes cast in the election. More than half of all the votes cast in the election. Council, you understand the meaning of the word casting?
Yes, voting.
I mean, what is to cast?
Voting.
Yes. You receive a paper from the staff, you fold it, you put it in the ballot box.
Yes, my Lord.
That's casting.
Yes.
If we look at this article, 138.4a, which plainly states that the candidate, which says that the candidate will stand elected if he gets more than half of all the votes cast. And with our understanding of what casting is, does the term votes cast as used in the Constitution, plainly used in the Constitution, include rejected votes?
The rejected votes, my lord, are never counted as valid votes. So I believe 50+1 means the properly marked votes that are not in doubt.
Counsel, sorry, Counsel, we are looking at the Constitution. The Constitution says votes cast. You are introducing an element of validity. You are saying valid votes cast. That is not in this provision. This provision only says votes cast. Are you bringing the issue of validity by virtue of interpretation, or maybe you are relying on a certain decision somewhere?
No, my lord. The reason I've said the properly marked votes is because rejected votes don't go into determining the candidate because they are wrong in the first place. They are invalid. So you cannot validate that which is invalid right from the beginning. We can't tell who they intended, those people intended to vote as a president. So we can only determine 50+1 of the valid votes.
You're right. We cannot include rejected votes in the count for who is to be declared as the president. If you go down to statutes and subsidiary legislation, on that aspect, you will come across Regulation 69, Subregulation 2 of the Election General Regulations 2012, which now deals with the issue of valid votes cast. Valid votes cast. The issue of validity is now introduced by subsidiary legislation. Now, could you be aware whether the issue of validity of votes cast was dealt with in Raila 1, 2013, and Raila 2, 2017? Was it one of the issues in these petitions?
I'm not very sure whether it was one of the issues, but I know the main section that was due for determination was Section 83 of the Elections Act that dealt with the issue of transmission and whether if the flows with a non-compliance with procedures and the law would affect the number of. You need to show that it affected the final results. So essentially, we would say probably yes, by virtue of looking at whether the processes affected the final vote.
So was it an issue, or was it not in both or any?
The issue of number of votes was an issue, but in both petitions, I think the focus was mainly on Section 83 of the Elections Act.
Okay, and maybe we can leave that discussion there. And just to wrap it up, I just want to go back to the issue of the votes cast and the valid votes cast. If you look at the two provisions which I've referred you to, the word votes cast is used in the Constitution, and the word valid votes cast appears in the subsidiary legislation. Now, how would you justify using subsidiary legislation to limit the plain meaning of a constitutional provision? How does it come in?
Thank you, my lord. My understanding of subsidiary legislation is that it operationalizes so that it brings